In our broad theme on the President of India, now we will be discussing the most interesting and equally debatable part, namely the emergency powers of the President. The Chief of the Executive in India has been assigned with certain special powers to meet the arising critical situation. This is required since with the normal powers it is not possible to resolve all the problems that arises at an abnormal situation. Now what exactly is meant by an emergent situation is difficult to define since the very term emergency is a highly elastic one and it changes with the passage of time. The meaning changes with the passage of time. However, K.V. Rao in his book entitled Parliamentary Democracy in India has stated that emergency creates such a critical situation whereby immediate action becomes inevitable. In fact, it creates such a situation which is sudden and definitely unexpected in nature. So to deal with this extraordinary situation or to deal with such a critical situation, the Constitution of India has provided the emergency powers to the President, who happened to be the Chief of the Union Executive. These extraordinary powers has been mentioned in Part 18 of the Indian Constitution under the title of the Emergency Provisions. The Constitution, in fact, stipulates three kinds of emergencies, namely the national emergency as enshrined in Article 352 of the Indian Constitution, state emergency as mentioned in Article 356, and financial emergency as mentioned in Article 360 of the Indian Constitution. We will be discussing these emergency provisions one by one in a great detail. The first of these three emergency provisions happen to be the national emergency. Article 352 of the Indian Constitution empowers the President to proclaim national emergency if he or she is satisfied that a situation has arisen or is likely to arise whereby the security of the country is threatened due to war, external aggression, or armed rebellion within the country. The satisfaction of the President, however, for all practical purposes implies the satisfaction of the Council of Ministers headed by the Prime Minister. Such a proclamation is required to be laid before the Parliament, and such a proclamation can remain in force for a period of 1 month at the most, beyond which it shall require the approval of the Parliament. If the Lok Sabha is not in session or stands dissolved, then the Rajya Sabha may also approve it. But even if it is being approved by the Rajya Sabha, it shall require the approval of the House of the People within 30 days of the first meet of the new Lok Sabha. The 44th Constitutional Amendment Act of 1978 has made certain changes in the emergency provisions. First of all, the phrase internal disturbances has been substituted by the words armed rebellion. Secondly, the time or the duration of emergency has been reduced to 1 month. Instead of 2 months, it has been reduced to 1 month, beyond which it shall require the approval of the Parliament. Thirdly, it has been mentioned in the Act that the President can proclaim the emergency on the written advice of the Council of Ministers. Fourthly, a specific time limit has been set. The duration of the emergencies can be extended for not more than 6 months at a single instance. However, no maximum time limit has been specified so far. Finally, or fifthly, it has been also mentioned in the Act that at least 1/10 of the members of the Lok Sabha may give their requisition for a special session for reconsidering the continuity of the proclamation. Such a notice shall be presented or shall be addressed to the Speaker if the House is in session, or to the President if the House is not in session. Within 14 days of the receipt of such a notice, a special session has to be conducted. Finally, it has also been argued that such a proclamation may be viewed or revoked by the President of India at any point of time by a subsequent proclamation. Now let us see the effects that the national emergency could have. The effects of the national emergencies can be discussed under the following heads. Firstly, the executive, legislative, financial, and finally, with regards to the fundamental rights. So far as the effects of national emergency on the executive power is concerned, the executive authority of the union government can be extended during the proclamation of the national emergency. It can be extended to the point of giving directions to the state government so as to how the executive powers of the state can be exercised. This is in accordance with Article 353A of the Constitution. Normally, the executive authority of the union government can be extended on matters as specified in Article 256 and 257 of the Indian Constitution. But during the proclamation, it can be extended to any other matters as well. Though the state executive or though the state government is not suspended, but the state executive is placed under the direct control and supervision of the union government once a proclamation of national emergency is being made. Finally, it seems as if the entire administration of the country is carried out as if there is a unitary system with local subdivisions. Now let us see its effect in the legislative terms. So far as the normal tenure of the Lok Sabha is concerned, it shall be extended to a maximum period of 1 year at an instance, and it cannot be extended for more than 6 months after the proclamation has ceased to be operative. The normal legislature of the states are not suspended, but the distribution of the legislative relations between the union and the state government has been suspended. In fact, the Parliament is empowered to make laws on any matters which are included in the state list or originally being placed under state's jurisdiction. Now, let us see the impact of the national emergency in the financial context. During the operation of the proclamation of national emergency, the President is empowered to modify the provisions of the Constitution with regard to the allocation of financial resources between the union government and the states through an order issued by the President. Such an order shall be operative for that financial year, and such an order of the President shall be subject to the approval of the Parliament. So far as the fundamental rights are concerned, during the proclamation of national emergency, Article 358 automatically comes into operation, thereby suspending Article 19, that is, right to freedom. And again, Article 359 of the Constitution enforces the suspension of the fundamental rights which are specified in the President's order, except Article 20 and 21, that is, right to life and personal liberty. Again, it has been mentioned that during the proclamation of national emergency, Article 32 and 226 can be suspended. These are the two articles of constitutional remedies which helps in the enforcement of the fundamental rights. National emergency has been proclaimed thrice in our country. It was first proclaimed in the year 1962 when China attacked the Indian borders in the northeast, and it lasted till 1969. It was proclaimed for the second time in the year 1971 during the Second India-Pakistan War, and while the second proclamation of national emergency was on, it was proclaimed once again for the third time in the year 1975. Both the second and the third proclamation was revoked in the year 1977. Now let us see the state emergency provisions. The provision of state emergency is mentioned in Article 356 of the Indian Constitution. This article empowers the president to take over the administration of the state in the context of breakdown of constitutional machinery of that state. Now, it also implies either on the basis of a report presented by the governor of that state to the president or on the satisfaction of the president himself. That implies once again the satisfaction of the union cabinet. This article can be invoked by the president on any state. Such a proclamation can continue for 2 months, beyond which it shall require the approval of the parliament. The constitution provides that resolution to this effect must be passed in each house by a simple majority. It has to be passed if the Lok Sabha stands dissolved, or if the Lok Sabha is not in session, then it can be approved by the Rajya Sabha, but in this case it shall cease to be operative for only a period of 30 days. The 44th Amendment Act, however, has laid down that the state emergency can be extended for a period of not more than 6 months at an instance. However, it must be made clear that the very state emergency has created furor in the political arena of the country. So far as our discussion on the state emergency is concerned, it is worthwhile to take note that the very phrase breakdown of the constitutional machinery as described by M.C. Setalavad as is of widest import. It may implies anything from actual disintegration of the states to a struggle of preventing the political parties of that state from forming an alternative government. In fact, state emergencies created such a political turmoil that it has been accused that most of the rulers at the center often misuses these articles. A scrutiny of the political development in this connection leaves an impression that the political leaders at the center have used this article to such an extent merely to serve their own political interest. Let us examine the effects of the state emergencies. First of all, if a state emergency is being proclaimed, then the president takes over all the functions of the state government in that state, and the entire administration of the state is carried out either through the governor or an administrator appointed for that purpose. Secondly, since the state legislature is out of work, it is up to the parliament to pass the bills and the budgets regarding that state. Thirdly, it has been found that if this Lok Sabha is not in session, then the president may issue an order authorizing the state, authorizing to meet the expenditure from the consolidated fund of that state. Fourthly, it has been discussed that the president is empowered to make relevant changes so far as the state authority is concerned. The president can even ask the union government, may confer powers to the union government, and may even impose duties to the union government, its authorities, or its officials. Finally, what is interesting to note here is that this type of emergency does not give or does not entitle the president to curtail or to take away the powers of the state high court. Now let us examine the financial emergency. If the president is satisfied that a situation has arisen in which there is a financial instability or credit of the country or any part thereof is in danger, then the president may impose financial emergency under Article 360 of the Indian Constitution. The effects of the financial emergency. First of all, the executive authority of the union government during a financial emergency may extend to the point of giving directions to the state government so far as the financial propriety is concerned. Secondly, the president is empowered to reduce the salaries and allowances of all or a particular class of persons who are in service of the state governments and so on. Again, the money bills or any other bills that are applied to Article 270 of the Constitution may be reserved by the governor of that state for the consideration of the president. So far our discussion on financial emergency is concerned, it is worthwhile to take note that the language of Article 360 is delightfully vague. It does not give us any clear idea whether financial emergency is to be imposed for the whole of the country or any part thereof. Again, while other emergencies shall be declared based on some factual situation, financial emergency can be invoked by the President simply on the advice of the Council of Ministers headed by the Prime Minister. One of the most important factors so far as a financial emergency is concerned is that it has a tremendous psychological impact. Finance is a very delicate matter, and an emergency imposed on finance may lead to panic amongst the citizens and might create economic instability in the country. So instead of dealing with an emergency situation, this financial emergency might lead to another emergency situation. However, till date, financial emergency has not been invoked in our country. Now, so far as the emergency provisions of our Constitution is concerned, critics share certain lurking apprehensions. Let us examine some of the points that they have upheld so far with regard to the emergency provisions. First of all, it has been argued by many that the emergency provisions give sweeping powers to the President, thereby turning his position or his role from a mere guardian to that of a power-drunk ruler. Secondly, the emergency provisions is incompatible with the doctrine of federalism. Thirdly, if there is a political crisis in the state and the president declares a state emergency in that state, then there might arise a situation in which it might appear as if there is a great tussle between the union government and the citizens of that state. Finally, what is a matter of grave concern is that the duration of national and financial emergency can be extended to any length of time. And it implies or it means that the union government may not like to revoke it even after normal situations prevailing in the country. Now, to view the real position of the Indian President, it is essential for us to review the political system of the country. At the same time, it is also essential for us to examine the vision or the objective with which framers of the Indian Constitution had in their mind in creating the post of the President. So far as the position of the Indian President is concerned, here it must be noted that in a parliamentary form of government, the tenure of the executive is dependent on the will of the legislature, while in a presidential form of government, the tenure of the executive is independent of the will of the legislature. Now, so far as the position of the Indian President is concerned, the scholars have been divided into two major groups, namely the political school and the legal school. The advocates of the legal school were of the opinion that the President is the real executive. Exactly on the other hand, the advocates of the political school believe that the President is a mere constitutional head. For our convenience, we will be discussing the views forwarded by these two schools one by one. Firstly, we will be discussing the arguments forwarded by the advocates of the legal school who believe that the President is the real executive. First of all, Article 53, Section 1 of the Indian Constitution clearly states that the executive power of the Union shall be vested on the president, and he shall be exercising these powers either directly or through his officer subordinate to him. According to Article 74, Section 1 of the Indian Constitution, there shall be a Council of Ministers to aid and advise the President. To many constitutional experts of this school, the Council of Ministers and the subordinate officers as mentioned in Article 53, Section 1 and the Council of Ministers as mentioned in Article 74, Section 1 are the replica of each other. So to them, the Council of Ministers are the subordinate officers who are being placed under the President, and it is a President who can exert commands over them. Secondly, it has been argued that according to Article 75, Section 1 of the Indian Constitution, it is the President who appoints the Prime Minister and the other ministers. Not only that, they hold their office during the pleasure of the President. So it is quite known to us that the President has to abide by the advice provided to him by the Council of Ministers. But yet there are areas which may be termed as what may be called the prerogative powers through which the President may act independently. Thirdly, when the Parliament is not in session, the President may promulgate an ordinance if he is satisfied that a situation has arisen in which immediate action becomes necessary. Fourthly, the entire administration of the state is carried on in the name of the President. All the decisions and the directives issued by the Union government are taken under his name. How the directives are to be made effective depends on the rules and regulations which are to be made in the name of the President, and they are made not by the Council of Ministers but by the higher officials in the various departments of the administration. Fifthly, the Constitution of India has provided extraordinary powers to the President, which is more popularly known as the emergency powers. Now, the President may proclaim an emergency if he is satisfied that a situation has arisen. Not only that, the President is also the supreme commander of the armed forces. Now, sixthly, the 42nd and the 44th Amendment Act, though had made it obligatory on part of the President to abide by the advice provided to him by the Council of Ministers headed by the Prime Minister, yet the 44th Amendment Act had made an addition to the provision, according to which the President may ask for reconsideration of the advice provided to him by the Council of Ministers. Now, this addition further provides another or adds another power to the list of powers being entrusted to the President by the Constitution of India. Now, seventhly, nowhere in the Constitution it has been mentioned that the punishment, if the President declines to act on the advice of the Council of Ministers, then the punishment which the President may entail. Though the Constitution of India provides for the procedure of impeachment on the basis of which the President may be removed from his office on the grounds of violation of the Constitution. Now, even the procedure of impeachment requires a majority which is not always available to the Union Ministry. Finally, President also takes an oath to protect and preserve the Constitution. Now, if the President feels that an advice which is being given to him by the Council of Ministers goes against the Constitution, then he may act otherwise. He may decline to act on the basis of the advice provided to him by the Council of Ministers and thereby face the consequences. Now let us see the arguments which are being placed by the second school of thought, that is, the advocates of the political school who believed that the President is a mere constitutional head. First of all, it is an indisputable fact that India has adopted a parliamentary form of government in which the President has been designated as a respectable executive of the country. parliamentary form of government as adopted in India is based on the model of the British Constitution. Now, just like the British Crown, it is expected that the president in India should act accordingly. Secondly, in carrying out the administration of the state, it has been found that it is the Council of Ministers headed by the Prime Minister who are responsible to the legislature. This once again indicates that the Prime Minister and his Council of Ministers occupies or enjoy greater powers since since without granting powers, the question of responsibility would not have arisen. Thirdly, Article 74, Section 1 of the Indian Constitution says that there shall be a Council of Ministers to aid and advise the President of India, and the President has to act on the advice provided to him by the Council of Ministers headed by the Prime Minister. So this indicates that there is hardly any scope of reserve powers left for the President of India in which he might act independently of the Council of Ministers. Fourthly, it has been argued that the 42nd Amendment and 42nd and the 44th Constitutional Amendment Act has made it obligatory on part of the President to act on the advice of the Council of Ministers. Fifthly, it has been argued that the President is not directly elected by the people. So, he cannot claim to be a true representative of the people. On the other hand, the Council of Ministers and the Prime Ministers are elected by the people. So, they are the representatives of the people in the truest sense of the term. Sixthly, it has been argued that the authority of the President is tied up with the acts of the Parliament and also with other elaborate arrangements like the National Defence Committee and so on. Now, this again indicates that the President cannot act against the acts of the Parliament. Seventhly, the President is empowered to get acquainted with the decision while the final decision is being taken by the Prime Minister and his cabinet so far as the policy formulation and execution is concerned. Finally, so far as the judgments of the Supreme Courts are concerned, we find that these judgments highlight that the President is required to play a mere constitutional role. After viewing both sides of the controversy, to conclude, we can say, so far as the position of the Indian President is concerned, much depends on the personal equation of the office holder and also the role being played by the President at exceptional crisis.